Excuse me, time out. I'm Black, and guess what? I'm not wearing a do-rag on the screen because I'm in a courtroom. So everybody go get your wrap on. What did she just say? I have no idea. First, you're saying you make money move. Don't know what that is. That's going to be $1,000 fine.
All right, guys. Today's courtroom hearing goes off the rails almost the moment it begins. The defendant is in court on an unauthorized use of a motor vehicle charge, but before the judge can even address the case, a dispute breaks out over courtroom attire. What starts as a simple instruction quickly turns into a tense exchange that shifts everyone's attention away from the actual charges. Judge Boyd immediately makes it clear that courtroom rules apply to everyone, and from that point forward, you can feel the tension building with every response. Instead of focusing on her legal situation, the defendant seems more interested in challenging the court's authority, and that's rarely a strategy that ends well. Watch closely and let me know what you think. Did Judge Boyd handle the situation the right way, or would you have approached it differently? Let's dive in.
Just 1 second, I'm sorry. Ms. Trevino?
Yes, ma'am.
Are you wearing that headdress because that's your religion, or is there something else going on?
What are you talking? My do-rag?
Yeah, you need to take that off. I don't know where everybody thinks they are, but you're in court. How long is it going to take your client to remove her do-rag and dress appropriately and be ready for court, Mr. Myrick?
Oh, no. Honestly, I thought that was kind of native scarf or something on her head, but maybe it wasn't. All right.
I thought it was okay for me to wear it because I was in court. I was in my house.
Oh,
No one told me that I had to dress properly in my house, so I wasn't aware of that. Sorry, that's my fault.
No, you're in a courtroom. And honestly, I don't know why anyone would want to be seen in public with a do-rag.
That's what we do, parades. It's a Black culture.
Excuse me, time out. I'm Black, and guess what? I'm not wearing a do-rag on the screen because I'm in a courtroom. Not only am I not wearing a do-rag, I'm not picking up unauthorized uses or criminal cases. So please, don't try to tell me what's happening with the Black culture, because honestly, I believe
we're not comparing and contrasting. I'm talking about
older
me, not
than you, and I know more about the Black culture than you, and I respect the Black culture by remembering that my ancestors were slaves, and I'm not going out picking up criminal cases. So this is what we're going to do with yours, Mr. Myrick. Since she want to be all, I'm hard, she can be in court. So this is being recalled tomorrow, and she'll be in court. Thank you.
Look, we'll
see you in court tomorrow at 1:30. It's the 187 District Court, 4th floor, 300 De La Rosa. And know that you're not allowed to wear a do-rag in court. And no, do-rags are not Black culture. Do-rags have been invented recently. So everybody go get your wrap on. See you at 1:30, Mr. Myrick. Deputy Laura, Deputy Mejia.
Yes, Judge.
Regardless of what she believes to be Black culture, do not allow her in the courtroom with the do-rag on.
Yes, Judge.
And if she's not dressed appropriately for court, then we will send her home so she can become dressed appropriately.
Yes, ma'am.
Now I'm going to have to start giving history lessons, Brenna. Young Sutherland-Trevino, is she dressed appropriately, court, without a do-rag on her head?
Yes, ma'am.
Calling 2021 CR 0666, State of Texas versus Faith Aaron Sutherland-Trevino. Can I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
James Marat for defendant.
Mr. Trevino, I'm showing you a document entitled Court Admonishments. Did you review those documents with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
I cannot hear you. Yeah?
Okay, first of all, it's not yeah. It's either yes or no. Second of all, could you get into a stationary position and stop the swaying back and forth?
I said yes, ma'am. I never said yeah.
No, you said yeah, because the court reporter has taken down everything that everyone is saying. So in this courtroom, it's either yes or no. Do you understand?
Yes, ma'am.
What you're charged with is unauthorized use of a vehicle. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility. Did you understand?
Yes, ma'am. Yes,
I didn't hear.
Nobody heard her.
Yes, ma'am.
Can you not speak up? Is there an issue?
Oh, I said yes, ma'am, like 3 times.
No, you didn't. And here's the thing. You need to speak up and you need to stop swaying. Do you understand?
Yes, ma'am.
You were on this Zoom yesterday talking about do-rags were a part of Black culture. Well, let me just tell you this. Swaying, not saying yes or no, that's not a part of the Black culture. That's just you doing silly things while you're on Zoom, and the court will not be tolerating it. Do you understand?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Next, I'm going to show you what's entitled plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is requesting a $1,000 fine recommending deferred adjudication. There's to be no contact with Shakira Baker, Shukria or Shukia. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 120 hours of community service, restitution, and CATS 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? Are we proceeding with sentencing?
No objection to that. We hope so. Yeah.
Anything you wish to say on behalf of your client?
Well, in the fact that she's really on her own and she's doing her best. I think she just has to be careful of the company she keeps. But she doesn't have, to my knowledge, alcohol or drug issues at this time. Perhaps a little bit of some mentoring would be helpful for her in obtaining stable employment.
Ms. Trevino, how old are you?
I'm 18.
If you're drug tested today and know you're going to be drug tested today, what are the results going to be?
Positive.
For what?
Marijuana.
And what else?
That's it.
Who are you living with?
Myself.
How far did you go in school?
I dropped out 9th grade.
Why?
Because I just was going through things and I wanted to make my money.
All right. So dropping out of school, I think we can put a checkbox by that's not a part of the Black culture.
I'm going back, so.
Well, going back and going back are two different things. You're not going back. You're not there.
I am there. I got my computer. I already went back. I go to CAN.
What did she just say? I have no idea.
It's off topic anyway. That's off topic.
Okay, see, I think this is what you don't understand. As a condition of your deferred adjudication, I can have you taken into custody, and then you can get on topic at the Bexar County Jail. Whatever question I ask you is on topic.
I go to school, so I answered your question.
What did she just say? She will not open her mouth and speak so that somebody can understand her. Again, that's something that's not a part of the Black culture where we can't understand what each other is saying. So where are you at?
At this point, the atmosphere in the courtroom becomes even more tense. The defendant continues responding with visible frustration, while Judge Boyd remains focused on maintaining order and keeping the hearing on track. One thing that's easy to forget is that judges aren't only evaluating the facts of a case, they're also responsible for ensuring the courtroom operates respectfully and efficiently. The judge repeatedly gives the defendant opportunities to cooperate, but every interruption and confrontational response only makes the situation more difficult. Whether someone agrees with the courtroom rules or not, showing respect and listening carefully usually gives a defendant a much better opportunity to be heard. Sometimes it's not just the charges that influence how a hearing unfolds. It's also the way people conduct themselves once they're standing before the court. What do you think? Was the defendant simply frustrated, or did her attitude make an already difficult situation even worse?
Since you're saying you go to school.
9th grade.
Where are you attending school?
Texas Can.
What is your answer to that question?
Attending San Antonio Can.
How long have you been there?
I just started this year, so probably like, I think I've been at Can 3 months.
How are you supporting yourself?
I'm getting unemployment and make money moves. My hustle is worth that. That's how I pay my bills.
Hustle is where
Side jobs. I do side jobs to pay my bills.
Okay, let's back up a little bit. First, you're saying you make money moves. Don't know what that is. And then you say you're hustling. What do you mean by hustling? What exactly are you doing?
I sell body wash. I sell makeup. I do like electronic stuff on the side with people, that type of stuff, like side jobs.
Where are you getting makeup from to sell?
I got connects. My girlfriend. She gave it to me and I said it.
You got connects. Here's the thing. People, could we all pretend, even if it's not true, let's pretend like we have formal education, that we've went to school. And let's stop using slang. Let's start speaking in complete sentences. And every complete sentence must have at least two things, a noun and a verb, at the very least. So let's try doing that and let's be better. You're going to get a job. If you're living by yourself, you need to be employed.
Get a job, because right now I'm getting unemployment. I've been having issues with the unemployment, so that's kind of been an issue. So I'll probably end up back with a physical job like McDonald's, for example. And that's
what I'm telling you is you are going to have a job.
Oh yeah.
Collecting unemployment means, the very definition of it means you don't have employment because you're unemployed. And the 187, you're on probation, you will have employment. That's going to be $1,000 fine. No, I'm not probating it. 2 years deferred adjudication. There's to be no contact with Shakira Baker. And who are these people you were with in this vehicle?
My friends and my siblings.
All right. 2 years deferred adjudication. There's to be no contact with Miss Baker, Abel Ramos, Nathaniel Mejia, Priscilla Salazar, Amber Rocha, Jennifer Rocha, and Sharon Riles. There's to be weekly Zoom reporting, proof of employment within 30 days. And Rebecca, it needs to be a real job where she's getting a real paycheck and paying real taxes. 120 hours community service restitution. Cats 1 and 2. I'm going to want field visits at least 2 times per month at wherever she's staying. And I want it to be random. Rebecca, is there anything else you need?
All right, the court is calling 2021 CR 0666, State of Texas versus Faith Aaron Sutherland-Trevino. Can I have parties announced for the record for the state?
Joe Ray Garcia.
For the defense?
Jeff Mulliner for Faith Aaron Sutherland-Trevino.
And are you Ms. Sutherland-Trevino?
Yes, ma'am.
Ms. Sutherland-Trevino, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review this document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Faith Aaron Sutherland-Trevino on deferred adjudication in 2021 CR 0666 for the offense of unauthorized use of a vehicle on March 30th, 2021 for a period of 2 years and extended for 1 year? Is that you?
Yes, ma'am.
State?
Violated condition number 2 on or about the 12th day of November 2021 in Bexar County, Texas. The defendant, Faith Aaron Sutherland-Trevino, did then and there test positive for marijuana in violation of condition number 2.
How do you plead to that? True or not true?
True.
Ms. Sutherland-Trevino, did you understand by pleading true to violation of condition number 2 The court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is that an agreement?
Yes, Your Honor. We ask that the court adjudicate the defendant, revoke probation, sentence the defendant under 1244 of the Penal Code to a sentence term of 30 days, Bexar County Jail, and if it please the court, this judgment be satisfied.
Ms. Sutherland-Trevino, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will follow your agreement as previously stated. The court is finding violation of condition number 2 true. Court will grant the motion, find you guilty, not grant you community supervision, sentence you to 30 days in the Bexar County Jail under 12.44. Court will find that the judgment is satisfied, showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am, I do.
If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, Ms. Sutherland-Trevino. We can go off the record. Ms. Trevino, I saw that was the second motion to revoke, and you just would not stop using marijuana. You're gonna have to make a decision on what you want to do with your life. If you want to continue to be in and out of jails, Bexar County Jail and other places, you can choose to live that way. Life is pretty simple. People make life so difficult. If you follow many of the rules, everything will be just fine.
By the end of the hearing, it's clear this case became about much more than the original charge. The courtroom exchange serves as a reminder that attitude and decision-making can have a real impact on how legal proceedings unfold. According to later public reports, the defendant was arrested again in July 2025 on a separate aggravated assault allegation involving a deadly weapon. Those allegations are separate from this hearing and, like any pending criminal case, still have to go through the legal process before guilt or innocence is determined. Regardless of the outcome of that separate case, one lesson stands out here. Repeated legal trouble can lead to increasingly serious consequences, especially for defendants with prior convictions or repeated offenses. What do you think? Did Judge Boyd strike the right balance between patience and accountability, or should the court have taken a tougher approach? Let me know your thoughts in the comments below. If you enjoyed this courtroom breakdown, don't forget to like the video, subscribe to my channel, and turn on notifications so you never miss another real courtroom moment. Thanks for watching, and I'll see you in the next one.